Hi, everyone. Welcome to Crypto Law TV. I'm your host today, Kristi Warner, and joining me is the one and only meta law man, James Murphy. Welcome to the show, and thank you for joining us.
Hi, Kristi. Great to see you. Looking forward to the discussion.
Yeah, so you must be psychic because you actually predicted the SEC's latest move. But before we jump into that, I just kind of want to do a quick recap of the Ripple case. So obviously there was the summary judgment decision, and Judge Torres ruled that only the institutional sales were found to be the unregistered securities. She made it very clear that XRP itself is not a security, and that the sales between retail holders that didn't involve Ripple were not securities. No victims, there was no loss suffered by the institutional investors, and importantly, there was no fraud. So cool, sounds great for us retail holders. Then Judge Torres ruled on the remedies. There was no disgorgement, but Ripple did have to pay a civil penalty. So it seems like the case is closed, good and done, wrapped up, says it on the docket, case closed, but it's not over yet. What was your prediction?
Well, I thought that the SEC would appeal. Anytime you lose some or all of a case, you can appeal after final judgment is entered. One of the reasons I believe that is we all know that they attempted an interlocutory appeal, meaning it kind of in the middle of the case. They were so horrified by the decision of Judge Torres ruling that XRP is not a security, and that those transactions from the company and from the senior executives on exchanges were not investment contracts, therefore not securities. That horrified them, and they tried to appeal immediately. And so the fact that they would appeal at the end of the case was no surprise. I guess what surprised me is that a lot of people are saying the SEC would not appeal. I didn't understand that theory, but in any event, so here we are, and they filed a notice of appeal last week, and that gets the clock ticking on a bunch of deadlines.
Yes. So, one of the things that it said was, the next step. So they filed their notice of appeal, and there's multiple forms. You've been involved in the appeals process. Can you kind of walk us through what are the next steps of this?
Yes, I can. So the last one I was involved in went really, really quick. That was expedited treatment that involved the president of the United States at the time, Donald Trump, as well as the House of Representatives, and enforcement of a subpoena. And I was involved in that, and that one went really, really quick. It went from the Southern District of New York to the Second Circuit Court of Appeals to the United States Supreme Court hearing and decision, all in less than 1 year. So that's not normal. We're going to be on the normal track here with the Ripple. And the normal track is once you file this very short notice saying, hey, I intend to appeal, then you have 2 weeks, 14 days to fill out a form that's kind of a generic form of who are the lawyers involved, what's being appealed. And then you have to identify specifically the issues that you are going to be appealing. And so that's kind of the next interesting thing that we're looking for. It'll come 14 days from when they filed the notice of appeal last week. And then we'll know. And, my guess originally was that they were going to appeal the determination that those trades on the secondary market initiated by Ripple or the senior executives or the senior executives are investment contracts. Judge Torres ruled no. The SEC says yes, they are, and that I think is a extremely likely issue number one on appeal. And issue number two on appeal will be the zero out of disgorgement, which was not a surprise given the fact that the Second Circuit Court of Appeals at the end of last year ruled that you must have victims who have suffered pecuniary loss. That means lost money in order to have an award of disgorgement. And the SEC didn't have that. It was kind of shocking, really, to engage in 4 years of litigation, and the quote unquote victims, the investors that the SEC is representing, have no losses at all. And these are big institutions. The ones who are hurt, we all know, are the retail XRP holders. So the retail investors were damaged by this litigation by the SEC. And even the big boy hedge funds and wholesalers were not harmed at all. To me, it was embarrassing for the institution that they brought the case in the first place. But so the two issues on appeal will be what I said: the trades on the exchange and the disgorgement decision. Now there's a little wrinkle on disgorgement, and so now we're getting like into advanced law school. I taught law school classes. This is advanced. So a panel, meaning 3 judges of the Second Circuit Court of Appeals, ruled in a case called Goville that there cannot be disgorgement unless there are losses. The victims of the securities violations have suffered losses. And that ruling put them out of alignment with another Circuit Court of Appeals, the Fifth Circuit Court of Appeals. So when this case goes up and the SEC's appealing this, a different panel is not going to contradict the Goville panel of 3 judges, but there are something on the order of 20 judges at the Second Circuit Court of Appeals. So what I expect to happen, and we can just bookmark this, I guess, what I expect to happen is they will lose again on the disgorgement, and then they're going to ask for a rehearing en banc of the entirety of the judges on the Second Circuit to reconsider the Goville, really, as well as its application by Judge Torres. And this is the part where the XR people are really going to hate me. When they probably lose there also, there's only one move left, and that's to go to the United States Supreme Court about this disgorgement issue. So that is a possibility that it plays all the way out like that. So we're going to get identified the 2 or more. There's a third possible item to appeal, and that is the amount of the penalty. I think this would be a very, very weak argument because the judge has a lot of discretion, and she actually followed kind of a formula that exists out there saying how much you could charge somebody for a violation of the securities laws, and she followed that. She followed the section that says there's no fraud. It's not reckless here. It's kind of a garden variety. Okay, technical violation here. And she just multiplied the number of issuances of securities, and then by the penalty amount came up with 125 million. So it's possible they'll try that third one, but I kind of don't think so.
And I mean, the disgorgement, obviously, if they were in any other circuit, this could have played out very differently. But because they're in the Second Circuit, do you anticipate that they will fight tooth and nail on that disgorgement?
It's a big deal for the SEC. So for my entire career, and I practiced securities law for a long time, the SEC did not have to show any pecuniary losses in order to get disgorgement from a defendant. And so this is a big change, and it makes their job harder. And in particular, it takes away this threat. So a lot of what the SEC does is settle, and they have threats. Look, here's how much you're going to have to pay if you go to trial, and here's, and you go figure out how much you're going to pay in attorney's fees, and it's really expensive, and we're going to nail you with disgorgement, and then a penalty on top of that, make you, settle, make your life easy. So if they take that tool away in situations where there are no losses, then they're weakened in their enforcement program. And so, yes, I would not be surprised for them to take it all the way to the Supreme Court.
Wow. Okay. So I was actually surprised, maybe from a layman's standpoint, that the SEC was going to bother appealing. They're just involved in so much other crypto litigation. It's an election year. There's so many other things going on that I was surprised that they were bothering. But you called it. And Ripple also weighed in on, like, they gave a public reaction to the appeal. Both Brad and Stu have tweeted about how they are feeling about this whole thing. And one of the things that they brought up was that they're evaluating whether or not to file a cross appeal. And I'm just curious what you think about that possibility.
So I am a very big fan of bringing a cross appeal in this case. And by the way, I didn't give my traditional disclaimer. Obviously, I'm just popping off from the cheap seats and giving my 2 cents. It's not legal advice, and nobody should ever in their right mind make investment decisions based on anything the meta lawman says or tweets or whatever, obviously. But I'm a really big fan of cross appeal here, and I am in a small minority of people. I believe that the contracts where they sold XRP to institutions are not investment contracts. And I think there aren't a lot of people who agree with me on that, and that's fine. I don't care. That's kind of how I've been in my whole career, an outlier. But here's why. When these entities bought XRP at wholesale prices, meaning less than what it was trading for on retail exchanges, that was their objective, to make money as a wholesaler, just like any other wholesaler buys. Let's take an example. How about this one, Kristi? How about oranges? What if somebody went to the W.J. Howie Company in 1946 and said, hey, man, I hear you're going to be harvesting an enormous amount of oranges. Sell them to me, and I will go and sell them to grocery stores all over the country or whatever. And I'm going to make a markup on the oranges. Well, the wholesaler's not going into business with W.J. Howie. The wholesaler's not sharing profits with Howie. They're simply receiving the commodity at a discount and going to make a profit selling it to retail. The difference between what they bought it for and what they sold it for is not an investment in the W.J. Howie Company. And therefore, that everybody in their right mind would agree that's no investment contract. Well, in my opinion, that's what we've got with XRP and these sales to institutions. They were buying the XRP at a discount to sell to retail at a markup. They were not investing in Ripple, in the Ripple business, and sharing in the profits of Ripple. How do I know that? I know it for sure because there is a way to do that, and that's called buying stock in Ripple. Ripple is a private company, and you can buy shares on these exchanges that are doing secondary market trades for like employees or others who may have acquired shares in Ripple over the years. You can invest in a Ripple, and that would be a securities transaction. But buying the commodity XRP at a discount for resale to retail in a markup is not investing in Ripple. I believe that very strongly, and I know nobody agrees with me because you have a contract. Okay. You have a contract where it feels like there's an investment being made in the sense that Ripple is receiving money, for the XRP, and they're going to use the money to build, the Ripple infrastructure and the ledger and, talk to governments around the world about adoption and invest in the quote unquote SEC's favorite term ecosystem of Ripple and XRP ledger and ODL and all of that good stuff. That's true. But you know what? If you buy a bunch of oranges from Howie's going to buy fertilizer and more land and grow and pay people and grow their business. It does not matter.
Yeah.
So, in my opinion, I would like to see Ripple cross appeal and say those transactions with the institutions, even though there were written contracts, were not investment contracts because we were simply selling to wholesalers a commodity that they made money on a markup to retail. You can use other examples like diamonds. Diamonds is a good example. So, for instance, a wholesaler could go to the De Beers company, which kind of has a monopoly worldwide on diamonds. And De Beers might say to the wholesaler, okay, we're going to sell you a bunch of diamonds below, what they sell for at Jared and Zales and whatever. And then you can sell to retail. However, we don't want you to sell them all at one time. We want you to agree to hold on to them for a while because we want to manage the level of availability of diamonds around the world, which is exactly what De Beers does. Those restrictions, which Judge Torres called out in her opinion, doesn't change anything. They don't change anything. It's still a wholesaler buying a commodity to make a markup when it's sold to retail. And it's not an investment contract. Those buyers of the diamonds are not investing in De Beers. They're not going to share in the profits of the mining operation around in Africa and all around the world. These are two different things. And I believe that and again, I'm in the minority here. I believe Ripple's got a pretty good argument that those are not investment contracts. And therefore, the SEC never had any jurisdiction over any aspect of this entire situation.
I think that's a compelling argument. I think it's an interesting one. And I think I agree with you that it's worth shooting their shot. Definitely interesting. That's a good one.
So you want to talk about timing? So they've got 2 weeks. So we're going to find out pretty quickly on the cross appeal, and it's 2 weeks from something called the delivery of the transcript. Now, normally, if you have a trial, a transcript of all the testimony of the trial and the exhibits, getting all of that together takes time. But when you don't have a trial, you just have cross summary judgment and an oral argument, and that's it, and no witnesses. It's very quick. And so the transcript in this case was transmitted the day after the SEC did their notice of appeal. So the Ripple's got 2 weeks to file their notice of cross appeal, and then they'll have some time to identify what issues they will cross appeal on. But in my view, there's no real downside to doing that and to putting pressure on the SEC so that they understand that they have some real risk as well. It's not just, hey, upside, maybe we get Judge Torres overturned on those 2 items that we talked about before, but they've got some real downside that the whole case could come out from under them, in which case there'd be no penalty because there'd be no securities violations if I'm correct, and those contracts are wholesale agreements. You asked about timing. This is a little weird. You can sort of pick your day to submit your brief as an appellant. Appellant, last few letters are A-N-T. Appellant means the person who went first and appealed. You're the appellant, and then the other party is the appellee. And so once you get the transcript, you have, and it's transmitted to the Second Circuit, which they're in the same building down there in Lower Manhattan. You have up to 91 days to file your brief. And what you do is the appellant tells the court when they're going to file their brief. And if it's less than 91 days, the court says that's fine and dandy. And then once that happens, after that first brief is filed, then the appellee gets 2 weeks to look at the brief and then tell the court, here's when we're going to file our responsive brief, not less than 91 days from that. And then the final shot from the appellant is called the reply brief. And that one's pretty much firm at 21 days from the appellee's brief. So you got 90, 21, for a total of whatever that adds up to, a couple hundred days. But it can be longer. And in this case, I think that we're going to see a lot of amicus briefs filed. I could be wrong, but I think we will. I mean, Coinbase has clearly signaled this Ripple case is extremely important. We want our, interlocutory appeal from our own case granted so that we can get on the Second Circuit docket at the same time as Ripple. But even if that does not happen, you're going to have a bunch of players in the crypto industry weigh in on behalf of Ripple. And one of the things that we really, really, really need to see is members of Congress getting together and filing briefs. And I mean both Republicans and Democrats. And what I've called for is for Richie Torres and Ro Khanna and the rest of them to gather together their friends who are not hostile to crypto and submit a brief on behalf of Ripple. That the Second Circuit will give that a lot of weight. And certainly industry players for sure will weigh in as well. So that could delay things a little bit, but the rule of thumb is it's going to be a little over a year. So, my guess would be first quarter of 2026 would be the decision in the case, because after the briefing is done, could be a couple of months before there's a hearing, an oral argument, and then there's no telling how long they might take to issue a decision. Could be 6 months, could be 3 months, could be a year. But so my guess is somewhere in the neighborhood of first quarter 2026, we will see a decision. Now, there are other things that could happen. We have an election coming up, which if Gary Gensler is deposed because Donald Trump wins, or, John Deaton knocks off Elizabeth Warren and her power disappears and the fear that other Democrats have of her power goes away. Nobody thinks this is great, what's happening with all this crazy litigation that is forcing innovation out of the United States. And so we could see one of two things. One, Gary Gensler resigns or is fired and is replaced by somebody who is not looking to kill crypto and execute his or her portion of the overall Operation Choke Point 2.0. They want no part of it. They're going to do what's right. And what's right would probably be to settle or dismiss these cases, or at a minimum, stop the cases until Congress has ruled who gets jurisdiction over crypto. It's silly to ask judges to make these decisions when there's already legislation percolating that would say the SEC does not have authority over this industry. A number of things could happen. And I think there's probably better than a 50% chance that something happens to change the dynamics such that we could see these cases come to a close before the first quarter of 2026.
Okay. To your point, I watched bits and pieces of the recent SEC oversight hearing. And there's this hunger for clarity, and the commissioners claim that, definitely need it as well. But, Congress is like, would it be beneficial for it to be statutory? And they hem and haw. And to me, it would seem like Congress should make the laws and then the agency can go out and enforce them. It feels like the SEC is profiting off of the lack of clarity, and you can see that they're, depending on which case you're looking at, see the different arguments that they're making that are inconsistent. They will literally make the opposite argument to fit each case. And it's so frustrating to watch that as, someone that they claim to be protecting. I just see our resources going the wrong direction when we do have legislation that could solve this and could bring or keep innovation in America and let us move forward, instead of harming the companies that want to innovate in America and also the retail holders. And we were the only ones. I shouldn't say the only ones. Ripple was obviously harmed in this case, but the people that are supposed to be protected by the SEC were the ones that were harmed by the litigation against Ripple, against Coinbase, again, you know, all of that. It's our money that gets frozen. It's our access that gets denied while they're sitting here litigating something that could so clearly be taken care of through statutory oversight is how I would phrase it. But to your point, when you've got political divisiveness happening and you have platforms that don't quite match on their ideas as it comes to innovation in America, there are plenty of Democrats who are quote unquote pro crypto, which I would just say is actually pro innovation and pro technology and pro moving forward. But you're right that there's a power dynamic that is kind of in the way of that. And, you know, Fit 21 is something that we're just waiting on the Senate, right? Like we could get this moving. So definitely frustrating to see our taxpayer dollars going towards stuff that doesn't really seem like it should be going that way. But this is the political climate that we're in. But for the SEC, as you've explained, you know, the disgorgement aspect makes it difficult for them. So they have a motivation to try to knock that off. That makes sense. But aren't they also kind of risking it by raising the stakes with such weak arguments for the other things? If that's the route that they go, does this create even more of a compelling case for Congress to step in?
Yes, it does. And your points are perfectly valid. And it really, really bothers me as a lawyer because we're supposed to live in a country governed by something called the rule of law. And the rule of law means that we all get to know what's legal and what's illegal. You know, that's how it's supposed to work. When you drive down the road, you have a speed limit posted, and you then can decide, am I going to drive at or below the speed limit, or am I going to speed and risk getting a ticket? But at least you know the rule. With Gary Gensler, he refuses. You know, when Congress, you know, that has oversight responsibility over his agency says, hey, is this a security? I don't know, you know, because we don't know. His answer is, I'm only going to tell people when I sue them what they've done wrong, what of these tokens are securities. And of course, he maintained that position. The tokens themselves are securities for years. And now we think because of a footnote, maybe he's given up on that crazy notion, which activated John Deaton in the Ripple case in the first place. You know, so it's really frustrating, but it's really fundamental to who we are as a country, that we don't have to worry that some sheriff or some bureaucrat is going to declare what we've been doing is illegal without notice of here's the law, you know, and we don't have that here. What we have is a Supreme Court opinion about oranges from 1946. And we have a guy in charge who made up a term called, you know, digital crypto assets or crypto securities or whatever the hell he calls it. He made it up. It's not in the Federal Register. It's not in any statute. It's not in the 33 Act or the 34 Act. He doesn't get to make it up and then say, yeah, I'm going to destroy your business too. How about that? Pay me millions of dollars in damages and get out of the United States. That's not how it works. To your point, that's what Congress gets to do. They get to say, you know what? These things are going to be considered securities. These aren't going forward. And here's what the CFTC is going to do. Here's what the SEC is going to do. And by the way, everything I just said, Gary knows this is true because he testified to it in May of 2021. Exactly what I'm saying under oath, what he testified was truthful. He did not have authority to regulate crypto exchanges. He said it, and he said, I'd really appreciate it if Congress would get started on drafting up some legislation, because I think the SEC should have this authority to regulate crypto exchanges, and maybe they should have. But now that he's damaged the reputation of the institution so horribly, the chances of that happening are now dwindling toward zero. And so either the CFTC or perhaps an entirely new agency may be given the responsibility for regulating the crypto industry. But most of us, the vast majority of us, have wanted reasonable, intelligible regulation from the beginning. They've got it in the EU. They've got it in countries like Kazakhstan. Here in the United States, where we're supposed to have the #1 capital markets in the entire world, we got nothing but a 1946 opinion about some oranges. And Gary goes out on CNBC and says, it's clear as a bell, what the rules are here. Another funny thing is, by him going around saying these tokens are securities, he got this Prometheum business started. They can't operate if those aren't themselves securities. They have a securities license. And now, if they're giving up on this idea, we think, because of a footnote in the Binance case on these tokens that are themselves securities, then Prometheum has no business, in my opinion. I'm not, what do I know? Just spitballing here. Maybe it's a great business. But in any event, couldn't agree with you more. I think it does provide impetus to Congress to take action. I think the industry, led by the Coinbase stand with crypto thing and the fair shake thing, I'm not thrilled with everything any of them are doing, but it has delivered a message. Mm-hmm. That if you are going to be unthinkingly opposed to all innovation that has anything to do with cryptography, then you're in trouble as a politician, and you may need to look for another job. So I think that was a good and effective message. And because that is being conveyed, I'm kind of optimistic that we're going to see something pass in 2025 and possibly signed by whichever president it is, So anyway, that was a little bit of a long rant, but you're spot on. We're supposed to live in a land governed by the rule of law, not a land governed by Gary and whatever the political people who are pulling his strings tell him to do.
Yeah, well, and to that point, I think, another part of the problem, if we go back to, it was through a FOIA request that the American people found out that Elizabeth Warren's office gave Gary Gensler not only the questions, but also the suggested answers to her questioning of him in her oversight hearing. So when you have that kind of just collusion going on between the agencies and Congress to keep this facade up, the SEC brings in a lot of money through their litigation, but we're also spending a lot of taxpayer dollars to do this. And the harm to the companies is the lawsuit themselves. Whether the SEC wins or lose, Ripple being stuck here or Coinbase being stuck here, or, it's just, look at Library. Look what happened there. There is no Library anymore, right? So we've weaponized the court system in many ways, even outside of the crypto industry, but keeping it with crypto. We've weaponized the court system. We've weaponized the agencies. And I just think that we've got to get Congress to pass a law. And hopefully, no matter who the president ends up being, that's something, it sounds like both candidates have the same idea as far as we should not be kind of regulating through litigation, or, the enforcement actions are leading the way. We should have statutory clarity. So hopefully, no matter what happens in November, we as the American people can have that clear rule of law.
Well, yeah, you're right. The process is the punishment. And the SEC plays that for all it's worth. You are going to go through a lot of pain, even if you win. And that's why I have advocated for years that we need to amend the securities laws to say that if the SEC sues you and does not win, they've got to pay your attorney's fees. Because I don't understand any theory under which the SEC can cause a company to spend 10 million, $100 million to defend itself, then lose, and at the end say, oh, well, oops, sorry, you're out the 100 million. See you later. We're on to the next case, and have no, consequences. That doesn't make any sense to me. I do think who wins the presidency is going to be important. And here's why. I mean, today, Kamala Harris was asked if there was anything that was done by the Biden administration over the last 4 years that she would have done differently. And she said, no, I can't think of anything. Well, let's not forget, they're orchestrating Operation Choke Point 2.0 across all of the banking and securities regulators to destroy anybody with the temerity to get involved in crypto. And so, she could have said something like, that's not good. But she did not. And so, we're left in a situation where, hey, take Mark Cuban and Scaramucci's word for it, that she's with somebody who knows her is whispering in their ears, hey, it isn't going to be quite as bad next go round, maybe. But there's a lot of things they could have done and could do right now with 4 weeks to go before the election. They could ask for Gary Gensler's resignation tomorrow, and he would submit it. There is no scenario where the head of an agency is asked by the president to submit a resignation and he says, no, I'm good, I'll just stay. It doesn't work that way. And so there are a number of things that could be done. None of them are being done. And so I think people need to take that into consideration and make their own decisions about what issues are important to them. What's important is that we have a democracy and that everybody vote, and that all the votes be counted appropriately. And so that's what I believe in. My father fought for freedom in World War II. I'm trying to do my small, tiny part to promote freedom as well. And this is just a really, really precious right we have to vote in this country.
I agree. And I think it's something that you don't necessarily realize how impactful it can be. And there's so many different moving parts. It's more than just who the commander in chief will be for the next 4 years. Right. One last prediction I would like to get from you. Regardless of who the next administration is, Gary Gensler, in or out? And is he fired or is it resignation? How does he leave?
I believe he will be out before his term ends. I think if Trump wins, I think he will be fired. Now, he may be given an opportunity to resign. And if he doesn't do that, then I believe Trump will fire him. There's been a lot of discussion on Twitter and elsewhere about, does the president have the authority to do that? In my view, he does have the authority to do that. And my authority for that statement is former Justice Stephen Breyer has said it, the Harvard Law Review has said it, and the Yale Journal of Technology and Regulation has also said it. It hasn't been decided by the Supreme Court of the United States, but given the makeup of the Supreme Court of the United States, now I'm quite confident that the Supreme Court would uphold a termination of the chairman of the SEC. If Kamala Harris wins, I think that Gary will be viewed as a political liability. And I think that even though, there's still this anti-crypto army, I don't think they're on the ascendance. I think they're contracting, and you've got really smart, fun, intelligent people like Richie Torres that just torch Gary, and he's not stopping. If you keep him in there, it looks bad to have like an up and coming young superstar from the Bronx who's very, very liberal, just ripping Gary and making fun of him every time he shows up, that's not good, for the administration. And so I would say they'll find a way for Gary to exit the scene. Now, the question is that person then replaced? Is Gary replaced with somebody who is pro crypto, or at least knowledgeable about crypto? And that would be an open question.
Okay. All right. Well, we've got your predictions now. And, as the SEC appeal moves forward, I would love to be able to circle back with you and kind of chart this path together. And I just want to thank everyone for hanging out with us and going over all this with us. And we'll see you guys next time.
Thanks, Kristi.
Thanks.